I'm going to quickly try to introduce people and get into a lot of different topics. The description for the panel was written before any of us talked with each other, so we're going to do a number of things I think that aren't described. If we happen to get into the ABA standards for criminal justice, I'll tell you something about that because I've been the reporter for some of those standards for about the last 10 years. So by way of introducing, I thought I would involve the audience rather than just talk at you. So how many people here can tell me which of the panelists has a 2-year-old daughter? I was going to make you guess. I was going to hold my hand over their heads and have you applaud. So Julie Fry, sitting right next to me, is with the Legal Aid Society in New York. And she has a 2-year-old daughter. And she, let me see if I can make sure I can give you the right title. She is part of the DNA unit in the Brooklyn branch of Legal Aid and has been there for, the DNA unit was started in 2013. She has been in that office for about 11 years. She's a graduate of Rutgers Law School. I grew up in New Jersey, so I'm very happy that she was at Rutgers, but she's from Michigan. And she edits a weekly newsletter on current events in forensics. All right, who's familiar with that newsletter? If you're not, you should get her email address or whatever. Maybe she'll give it to you, and because it's apparently a very useful newsletter. And so we're very happy to have her here. All right, how many who on the panel has lived in Hong Kong? Who do you think? All right, who's admitting it? Paula. So Paula Wulff is actually the general counsel, or part of the general counsel's office in the FBI, the Federal Bureau of Investigation, Washington, D.C., and she I say that she runs the FBI lab. I think her title is what, Science and Technology Law Branch. She has a remarkably diverse set of events in her past, and I'm not going to go through all of them. But we did discover in talking today that we both worked for the same law firm in Washington, D.C. back in 1985 or 86. Paula was only 10 at that time. And then she went to law school in Tennessee. She's been a prosecutor in the district attorney's office in Memphis. She has worked at the NDAA, the National District Attorneys Association, for a number of years and has been with the FBI in her current position for about 7 years. She is remarkably well qualified to discuss what we will call the ethics of forensic science. All right, well, I've got 2 more things. Who's got a spouse who's a claims court judge in New York? Now it's down to 2 guys. All right, William Fitzpatrick has a spouse who's a claims court judge. He is the district attorney, I say in Syracuse, because I would not pronounce the county correctly.
I can't pronounce it either. Syracuse is fine.
He's been the DA up there, I think, for about 24 years. He is currently the president of the National District Attorneys Association. He has been a participant or a chair in any number of commissions in New York that have relevance to our topic. He served as co-chair, for example, on the Moreland Commission to investigate public corruption. He has chaired something called the New York DA's Association Committee on Fair and Ethical Administration of Justice, the Best Practices Committee. He is a native of Brooklyn, but has lived in Syracuse for many years, having gone there for law school. They're all lawyers, by the way. We don't have any lawyer. Well, I was going to say we don't have any scientists, but here's the last question. Who has a BA in chemical engineering? Phil Pulaski has a BA in chemical engineering and has a remarkable record as a law enforcement officer. He has a JD from St. John's University. He has retired recently as chief of the detectives of the New York Police Department, where he spent some 33 years in various positions. In that chief position, he supervised as many as 3,600 personnel, 150 different detective squads. He has been the commanding officer of 6 or 7 different task forces within the NYPD. He has served on the FBI NYPD Joint Terrorism Task Force in the wake of September 11th, 2001, and has a remarkable depth. Each of these people has a remarkable depth in the forensic regulatory structure that we've been hearing about today. Now, we're going to talk about ethics. When you teach legal ethics, as I do, you make the following joke. Legal ethics is to ethics as military music is to music. And then when I lecture prosecutors, I say, and prosecutors' ethics is like military music for the tone deaf. Now, I just want to tell you, I was a federal prosecutor for 8 years. I don't have a side in this. But it's hard to say what ethics means, right? It's hard to say whether are we talking about the ethics of lawyers in the system as it results to forensic science? Are we talking about ethics of forensic scientists? Are we talking about the ethics of law enforcement officers who are often the intersection between the two? Are we talking about defense lawyer ethics? And I want to tell you that I think, based on my hearing these guys talk over the last couple of weeks, we're talking about all of that. And we're going to go back and forth a little bit. So the structure here is going to be 6 minutes apiece. I'm supposed to be the enforcement officer of that. Other than that, I hope to say very little on this panel after this. We're going to start with Phil Pulaski. We're going to go to sort of in a little bit of an order here. Phil's going to talk, then Fitz is going to talk, then I think Paula's going to talk, and then Julie has the task of rehabilitating the lecture at that point from the defense perspective. And then we will have more of a discussion as in the last panel. My guess is these guys will start talking and I'll just be out of it. Phil.
Okay, so I'm starting off by hitting the wrong button here. If somebody can, from the outside, can help me get this slide up.
We got to get the people from...
All right, so in terms of ethics, I did exactly what you told me not to do, of course. In terms of ethics, I'm really going to frame ethics in terms of professional responsibility. So ethics can be a little too philosophical, I think, for me. And in terms of this professional responsibility, I want to address something that we're addressing on the National Commission on Forensic Science, and it is a very, very important topic, and that is transparency. So as the moderator mentioned, I have a background both as a scientist, was actually an intelligence officer right after 9/11, working with the FBI and members of the intelligence community, chief of detectives, and also been an attorney for 30 years. So I want to start off with the investigation. So an investigation in New York City, you get a robbery, person is shot, investigation starts, the police department collect evidence, and they deliver this evidence, they're the custodian of the evidence, they deliver it to a forensic laboratory, in this case the NYPD laboratory. So the evidence is obviously a component of the investigation. So the question that I'm trying to frame for the discussion is, how transparent does the investigator have to be in this pre-arrest scenario? How transparent does he have to be with the suspects? How transparent does he or she have to be with somebody who is not even a suspect? They're just somebody who's being looked at. And by extension, how transparent is the laboratory, who is given the evidence by the custodian, the investigator, who's responsible for that particular investigation? How transparent does that laboratory have to be? So I think the answer to the question is determined by the nature and rules of the process. And the process we call the criminal justice system, and it's adversarial. So to steal from that famous show, Law and Order, there are two parts to the criminal justice system: the investigation, which is done by one set of actors, and then the prosecution and defense, which is done by another set of actors. But I think what's key is that it is adversarial. So whether it's investigators versus suspects, perpetrators, persons of interest, however you want to frame it, or the people versus Smith, where the people are represented by the prosecutor and Smith is represented by the defense, it is adversarial. And so there is no full transparency. So society has made a decision that there will be rules. There will be rules that govern transparency. So one of my favorite rules, which is a very non-transparent rule, is of course the exclusionary rule. So from an investigator's standpoint and from society's standpoint, relevant material evidence that is highly probative is kept from the trier of fact because society is determined to strike a particular balance. And so it's about balancing. It's not necessarily about fairness. So what I wanted to do was I wanted to put up on this first slide this number 15. So this is a recommendation to the Attorney General from the National Commission on Forensic Science, and this is one of 16 tenets of a code of professional responsibility for forensic scientists, so forensic science service providers, medical science service providers. And it says currently, once a report is issued and the adjudicative process has commenced, communicate fully, this is a direction to the forensic science service provider, which would be a forensic analyst, when requested with the parties through their investigators, attorneys, and experts, except when instructed that a legal privilege, protective order, or law prevents disclosure. Now remember, this is only a recommendation. So the Deputy Attorney General Sally Yates, who's representative of Attorney General Loretta Lynch, this is going to be now looked at by DOJ. And I had a major problem with the original proposal. The original proposal, just to try to paraphrase, was communicate fully when requested with the parties through their investigators, attorneys, and experts, except when instructed that a legal privilege or law prevents disclosure. My first kind of issue that I'd like to throw out to the group, to the panel, was where is the investigator in this thing? So I'm the submitter of this evidence as the chief of detectives of the New York City Police Department, and I'm giving it to a laboratory to perform tasks on it. So where am I in this determination as to what happens to the results of the tasks that I've asked to have performed on my evidence? The second question I had was, where is the notice to me? Where's the requirement that the forensic scientists give me notice that these conversations are occurring? Now you can see that, and the third, and I guess the most logical one is, if I have a suspect and there's no arrest, and that suspect has gotten a lawyer, so I have A, and A is a suspect in the murder of B. Let's say A and B are married, and so A immediately goes out and hires an attorney. I don't have probable cause to arrest A. A is a suspect, may not even be a suspect. It's undergoing investigation. So does, under the old language, not the one you're looking up there, does the forensic science service provider now have a duty to communicate with A's defense attorney without clearing it with me, the investigator? As a result of that big problem, and as a result of some of my other colleagues on the commission, we ended up having this insertion of once a report is issued and the adjudicative process has commenced. But even that doesn't fully satisfy us. And the reason why is because I can have A, who is working as an accomplice with C to murder B. And so even though I've arrested A, I don't know about C. But C knows that A's been arrested, and so C gets an attorney. And so now my case is divulged without me having anything to say about it. So that's just some of the things I wanted to throw out there on transparency. How am I doing there, Rory?
You got another minute and a half.
All right, let me see if I can scroll down here. Here we go. So then the next kind of controversial topic I have is thanks to my colleague Chris Hammond, who put together a very, very good paper that was presented at the Asst Symposium, or conference. And as part of it, the question is asked, as you can see here, preliminary question is, who is the customer? Though there are many stakeholders in a public forensic laboratory, including the criminal justice system as a whole, the funding authority, judges, law enforcement, the defense, and the agency to which the laboratory report, these parties are not all customers of a laboratory. And so you get a difference to be discussed regarding a customer versus a stakeholder. And so in looking at that, if there is a corrective action that's taking place, certain decisions have to be made. How bad is that corrective action? Is it a reportable corrective action or is it not? What is the root cause analysis going to be? Who the heck are the parties that are adversely affected? Unfortunately, I can stand up here and say that as the commanding officer of the Forensic Investigations Division and then as the chief of detectives, I've had the pleasure, or maybe that's the wrong word, I've had the distinction of having some of the biggest corrective actions probably in the United States of America. And they're not easy, even when they're big, to try to figure out the tentacles of these things. And then actual notification is part of the corrective action. So who am I reaching out to as my customer? Is it everybody that's listed in that first sentence? Or is it who are really the stakeholders, or is it the customer? And if so, who is the customer? Same thing in the management of my laboratory on a daily basis. So I'll give you an example where there's tension between, or can be tension between the law enforcement aspects of the criminal justice system in terms of how to run a laboratory. So I may want my evidence priorities to be those cases that have not gone to trial because I'm trying to identify a suspect. And obviously, the district attorney is going to want as the priority the cases that have gone to trial, because there is evidence that needs to be proffered to a jury or to a finder of fact, and there are constraints that are placed upon the district attorney in terms of time limits and disclosure. So this is what I kind of like to think about, or have everybody here think about. What professional responsibility does the laboratory have to make everybody happy, to make everybody a customer, versus looking at this as a balance, just like the exclusionary rule is a balance. And that's the door opener.
I think that's great. Unless somebody has an immediate reaction, we're going to go to District Attorney Fitzpatrick.
Thanks, Rory, and good evening, everybody. I took office as president of the National DA's Association in Chicago last July, and as president, I get to set the theme of the conference, and the conference last July was prosecutorial integrity, and I invited a very good friend of mine, Barry Scheck. Barry and I have been on the New York State Forensic Science Committee for over a decade together, and we do a lot of, I think, really good things collaboratively together. And just a quick anecdote, a very close buddy of mine came up to me in a bar in Chicago and said, "Have you lost your mind, you know, putting Scheck on a panel of DAs, like we were going to reveal some secret code to him, consistent with our last panel." And he said, I'm really gonna take a bite out of his ass tomorrow when he speaks. I said, well, he's about 20 feet over there. I just had a beer with him. Why don't you start right now? And I swear to God, that guy goes, "You think he'd let me take a selfie with him?" And I actually I showed everybody the selfie the next day just to prove it actually happened. So it's an adversarial system. And I've never had a defense lawyer in 40 years come up to me and say, "Man, this evidence is really strong. We'll take the top count and the maximum sentence." It doesn't work that way, okay? I get it. I was a defense lawyer for 5 years. But what we do have in common is a common desire to exonerate the innocent. And that's where we can find common ground, especially in the area of forensics. It is inconceivable to me that an ethical prosecutor would contest the testing of a piece of evidence that is dispositive of the guilt or innocence of the accused, whether it's 5 minutes or 5 years or 5 decades after the conviction has occurred. Michael Morton case in Dallas, Texas, a person that I knew very well, John Bradley's out of a job because for 6 years he fought tooth and nail to prevent a bandana from being tested by the lab. That turned out to, without question, belong to the killer of Morton's wife, and Morton had been sitting in jail for over a decade for a crime he demonstrably did not commit. Up in my neck of the woods, one county west of me, a guy by the name of Roy Brown, convicted on bite mark evidence. And for years, the prosecutor resisted efforts to have the swabs that had been taken from the bite mark tested for DNA. Roy Brown did it on his own. He made jailhouse motions, and he was actually successful and wrote a letter to the actual killer, who sat down in front of a train with a suicide note, and it was obliterated. We wound up having to get DNA from one of his relatives. These stories, frankly, are just a stain on the criminal justice system. So what I suggest is that every DA's office, not only in New York State but in America, should have conviction integrity units and should have a liberal allowance regarding testing. Now, believe me, I want finality for victims as much as anybody in this room. But if the evidence is dispositive, there's simply no reason not to test it, particularly when not only do we suffer if an innocent person is in jail, but we also suffer because the actual perpetrator is at liberty to commit more and more crimes. So my suggestions fall into some very common sense areas. Number one, laboratories should be accredited. As I've discovered, to my astonishment, There are many labs in the United States of America that are not accredited. Some are actually run by DA's offices. It just sounds very, very foreign to me. Some labs actually have incentive programs where if there are arrests, there's a financial incentive for the analyst. This is crazy. What'd you do this week? Well, I exonerated 5 people. Oh, okay. Well, I'm going to dock your pay. What did you do? Well, it's just crazy. You also have to have labs that have ethical protocols for their analysts. My lab does in Onondaga County, and I would very much suggest to any lab director in the room or any scientist in the room that your lab do exactly the same. It's something that can be very, very intimidating for a lab analyst to have an unethical attorney suggest how he or she should testify and say, yeah, can you give me a little bit more? Things like that should be embraced by law enforcement. In addition, many scientific disciplines that are not accredited now should be accredited in the future. My own pet project is making fingerprinting an accredited science, because believe me, the problem isn't false inclusions, it's false exclusions, where people have left fingerprints at scenes and are getting away. So attorney standards, DA's offices, I've already said, conviction integrity units. For defense lawyers, this is a big state. I see, sadly, many defense lawyers in my neck of the woods under 18B that have absolutely no business trying a DNA case, because there's got to be a differentiation of standards. I have a number of other things, but I'm running out of time, so I'd just like to leave you with this last story about open-mindedness and testing evidence. I have a cold case bureau in Syracuse for many, many years. When the case of Marion Fisher, a woman who had been murdered in 1975, came up, a cop immediately raised his hand and said, "Forget it, the husband did it, we just can't prove it." And the husband was almost arrested, made some stupid statements, "Man, I dreamed I did it." His alibi was very, very weak. He flunked the polygraph, but he had never been prosecuted. And the case remained unsolved until we tested a piece of evidence at the crime scene at the behest of a DNA analyst. And it turned out that Marion Fisher, despite all the evidence pointing to her husband, was killed by a guy by the name of Carlton Gary, who just happened to be passing through Syracuse and who's now on death row in the state of Georgia for murdering 16 women the exact same way that he murdered Marion Fisher. And I remember that phone call to Jack Fisher like it was yesterday, but the best part of the story is the phone call he made to me 3 weeks after that, and I could hear his children and grandchildren screaming and yelling and opening presents and having fun in the background because his daughter had disavowed him for a quarter of a century, thinking that he had killed her mother. And because of DNA and because of the open-mindedness of people that work for me, we were able to solve that injustice for Jack Fisher. And I'm out of time, and I'll be looking forward to talking more on these topics.
Before we go to Paula Wulff, I thought I would just tell you all, because some of you may not follow the California Supreme Court, a week ago, in a case called In re Richards, the California Supreme Court found that a fellow named Richard should be released as innocent, or at least exonerated, based on a statute that the California legislature enacted in 2014. Some of you may know of this and others may not. How many people have not heard of this? All right. Most of you have, it sounds like, or you're asleep. Here's what the statute says, just so you know. For purposes of this section, this was a bite mark case, by the way, where the expert who testified in 1997 actually changed his mind about it 10 or 15 years later based on some technological advances that had happened. For purposes of this section, false evidence shall include opinions of experts that have either been repudiated by the expert who originally provided the opinion, or that have been undermined by later scientific research or technological advances. So as the technology continues to change, advance, improve, whatever, this statute provides that when an expert has given testimony in the past which has not taken advantage of that technology, it is false evidence, which is then a basis for granting a habeas petition no matter how many years later. That's an interesting statute that you all might consider having to do, vaguely at least, with the topic of ethics. Paula, I'll turn it over to you.
Thank you. Well, before I start, I want to make a standard disclaimer. The views I present are my own, and may not reflect that of the Bureau or the Department of Justice. The first thing I want to say is
I don't know if your mic is on. Fitz, can you maybe just handle yours?
Switch. Oh, portals. Great.
Thank you. Thank you. I don't own a Sony phone, probably never will. I have the flip-top phone and a blanket with smoke signals type of thing. I mean, I'm not on Facebook, I'm not on Twitter, I'm not in this century, and I don't regret not having that. I also want to say that I know nothing about encryption of phones. I can't answer any other questions. I heard more today about what went on or didn't go on or is speculated to have gone on regarding the San Bernardino phone. So I apologize. We were not able to send another person who might have been able to address any of those issues for you, and you're stuck with me. So here we go. I also want to say that in relation to something that Phil said earlier, the FBI's customer is dictated by statute. There was a woman over here earlier in the morning who asked whether or not were federal laboratories able to work with defense attorneys. And I want to point out that our customer, the FBI's laboratory customer, is dictated by regulation. That's 22 CFR 0.85G. And it indicates that our customer are law enforcement agencies. We cannot receive evidence brought into us or requested by the defense, by a defendant, to be examined. Now, having said that, our examiners, once they conduct their examination, are free to testify if a defense attorney subpoenas them. We make them available. We're agnostic after the evaluation of the evidence is done. So if you subpoena one of our examiners and they're available for the time frame that you need them, they don't have a competing subpoena, we do try to work with defense attorneys to either understand the science, to understand what the evaluation was, to have full discovery. We have an open file discovery policy at the FBI laboratory. We are not able to, again, because our customer is the prosecutor or the law enforcement agency that sent us in the information. We are required to provide them with a file, with the discovery material, but it is the entire file, including the raw data. Someone else asked a question earlier this morning about not one of the laboratories locally not providing raw data. We provide it in disk form. So all the information is available to you. We make it as much of a level playing field as we can once we receive the evidence to be analyzed. It's my understanding, and I think that there is an ATF individual still in the audience, but I was told by Mr. Bell earlier this morning that for the ATF, they can only accept evidence through a case agent. Is that correct? Yes. Okay. We are allowed to accept evidence through for state and local law enforcement agencies to send in, so we don't have that restriction. But again, it's not as though we're a private laboratory and we can take anyone who comes in through the door for evidence to be examined. So please bear that in mind. We cannot accept evidence unless you're from a law enforcement agency. So I wanted to talk a little bit, first a little bit about what Phil was talking earlier about the recommendations from the Forensic Commission on the Code of Ethics that is being promulgated. That is not yet adopted. That has been passed, or it is a recommendation that has been passed by the Commission. It has not yet been adopted by the Department of Justice, and it is subject to being evaluated by a committee at the Department of Justice to determine how it can be best facilitated. I am not sure that the Department of Justice will be able to allow or to direct federal examiners to speak with private examiners, private experts. I'm not sure that that's something that easily can be mandated, because the proper avenue for that is really in the court of law through cross-examination. But I also wanted to talk about a couple of scenarios and get your impressions or your opinions about these are types of ethical questions that we face in the laboratory every day. We heard earlier from the woman who was from one of the accrediting bodies, if you say in your protocols that things must be signed in blue ink and it's not, that's considered, that's a finding, that's a violation. Now, if someone signed one of our reports if we had that same requirement, which we don't, But if we had that same requirement, if someone signed something in blue ink and that report was never issued or left the building, would you consider that exculpatory? Would you consider that something that had to be reported out? Ma'am? Oh, you're shaking your head, so, okay, right. Because really, at that point, there's no harm, no foul, and it can be corrected before it leaves the building. If, on the other hand, you find that that same examiner is perhaps systemically doing the same wrong thing, then that might rise to the level of something that needed to be reported out, even if it's not just something as minor as signing in a different color of ink. So if it's a repetitive problem, I think that the laboratory is required or should be reporting something of that nature out, and obviously the examiner would have to be retrained on that. There's another matter where we had one particular examiner who worked with us for a very short period of time, and after he left, we found that there were some misrepresentations in some of his reports. Our laboratory then contacted all of the particular contributors of the evidence that had been sent in that this individual had worked, and asked to have it resubmitted to our laboratory. We reworked that evidence, issued new reports, and notified all of the parties involved with that. We also felt that it was appropriate that we contact where he had gone to the next laboratory where he was working, and to apprise them of the fact that this individual had this systemic problem, and where he had worked prior to joining us. So those are the sort of ethical issues that the laboratory that we faced in terms of what is our responsibility to disclose, what level of disclosure must happen, whether or not additional reports have to be run on this type of thing. So those may not be things that you would necessarily encounter, but those are things that we face at the laboratory on a daily basis. We also have had an issue recently where an individual had failed a proficiency test, and we have a policy in our laboratory that we require that to be reported out for a 5-year period. In other words, after a person fails a proficiency test, they're taken offline. They don't work on casework. They are retrained in that matter, and they have to wait for an entire cycle to be retested again with a proficiency test and pass that particular, whatever that issue was. But then that has to be reported for the next 5 years for every case in which he is involved. And we had an issue where in a pretrial, and I highly recommend a pretrial should be something you put on your calendar immediately after you receive any discovery of material with an examiner to be able to talk about it with them. But in this particular case, during a pretrial, it was disclosed to the party who was having the pretrial with this individual, it was an AUSA, that this individual had failed a proficiency test, and they had been informed of this on paper also through discovery. And then at trial, the AUSA crafted a question to this examiner such that he wasn't, it was sort of, have you ever taken a proficiency test, to which the examiner properly answered yes, but he wasn't given an opportunity to say and that he had failed the proficiency test. There hadn't been any follow-on questions for that. So again, our laboratory felt that it was our ethical responsibility to speak to the supervisor of the particular AUSA and indicate, just to inform them, we provided this material in discovery. We don't know if it was provided to the defense attorney, if that information had been downstream to the defense attorney. And we were not stepping into the case in any way, but we just wanted to make sure that everyone had the knowledge that they needed to make informed decisions about that. So those are the types of ethical issues that we as a laboratory face, which may be different than you would face in training prosecutors.